Welcome everyone to today's webinar, where we are excited to explore the incoming changes to the Australian Privacy Act and to discuss how we can prepare and potentially even capitalise on some of the opportunities that these types of changes can introduce to us in terms of increasing customer trust. I'd like to start by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of the land that we're presenting from today, and pay my respects to elders, both past and present. As we embark on this conversation, it's interesting to note that Australia was actually one of the first countries to introduce privacy legislation into law way back in 1988. For the tens of millions of Australians who have been impacted by one or more of the recent breaches, these updates are likely to be welcomed and considered potentially well overdue. For those here today, obviously we sit in a unique position as both individuals who have our data entrusted with organisations around Australia and potentially further abroad. But we're also on the other side of the fence where we are custodians of that data and have a responsibility under both the existing Privacy Act and the future changes to take reasonable steps to protect and preserve that information in a manner that is afforded I guess equally aligned to the importance of that data for all of us. This session is going to be around an hour long. I will hand shortly over to our presenters to introduce themselves. Before I do so, however, I'd like to just sort of highlight that we would love for this to be as interactive as possible, obviously as an online webinar that's generally facilitated via Q&A. So please do post your questions in the Q&A. We'll endeavour to get back to you with answers throughout the webinar and at the end during the Q&A section. And with that in mind, I would like to introduce our presenters today, David Ray, the Chief Privacy Officer of BigID, and Mariaan Wagner, Principal Consultant for Turnkey Consulting. I'll hand to David to introduce himself.
Sure, thank you, Tim. So I've got a particular interest in this in privacy, given that I've got a background. I'm a former software engineer, and I like to say I'm a recovering attorney, and so I bring both of these together with sort of a unique view because technology has so much of an integral component in what is modern data privacy. And prior to joining BigID, I spent 6 years as a director in data risk and privacy with PwC, where I led their privacy technology strategy and many implementations, including those with BigID and others. Marianne?
Thank you, David. Good morning, everyone. My name is Mariaan Wagner. I'm a principal consultant at Turnkey Consulting for just over 3 years now. Previously at SAP Australia, Deloitte, etc., and a lot of consulting experience in ERP-related governance, risk and compliance software and process implementations. Also assisting companies to develop and implement system and data security solutions. As David also said, it's such a very important topic nowadays, data security, and I'm also a part-time lecturer at a university, trying to integrate the real-world experience with academic content and also weaving the topic of data security into in that regard. Thank you, Tim. Moving on to the next slide. So to introduce Turnkey to you, so who are we? We are an international organization dedicated to assisting risk owners in bridging gaps across internal controls, access governance, cyber and data security. With over 20 years of experience, we focus on improving not only the technology, but also people and process improvements to truly help solve end-to-end challenges your organization faces, or the challenges that your specific team is trying to overcome, and there might be quite a few. Our core areas of expertise include data security and privacy, risk and compliance management, cyber and application security, and identity and access management, to name a few. Handing over to you, David, to give us an introduction to who is BigID.
Sure. So BigID was started around 7, 8 years ago when the GDPR first came into effect in Europe. And the idea was, how do we help companies respond to these new demands? An influx of rights requests and people needing to know about their data and be able to have control over their data. And so we've been in this space a long time, where we originally started with the concept of pairing people with data. And so that you can understand not only, you have a passport number, but whose is it? So we have over $250 million in capital that we've raised. We're fast growing, won lots of awards. Gartner has recognized us multiple times. We're always at the top right of the Forrester Privacy Wave, including the latest one that came out a few months ago. Industry awards. Think of us as a Swiss Army knife for privacy, security, and data governance. We help you understand by looking at your data what you have, and we work very closely with a number of system integrators, including Turnkey and others, as well as deep partnerships with ServiceNow, AWS, Microsoft, and so on. So let's move forward and talk about our agenda. So we're really going to talk about this in 4 sections today. We're going to first talk about what is happening. So as Tim alluded, Australia's had a Privacy Act since 1988, but what's changing now and why? And then why is this important for individuals? And we'll define what are individuals. And by this, I mean people whose data may be stored with organizations. And this definition has always included consumers, but it's broadening, and we'll talk a little bit about that. Then, why is it important for business to prepare? So that's most likely why most folks are here today, is thinking, okay, I need to get ahead of this. What do I need to do, and why? What's changed? We've had a privacy law. What's new now? And then we'll get into some very specific ways of how to get ready. What can we look at in the elements of a privacy program, the tools available to get started. So let's move on.
Thank you, David. So with regards to the Australian Privacy Act proposed changes, I think let's give some background. Moving on to the next slide. Thanks, Tim. So the Privacy Act is a crucial piece of legislation in Australia that governs the handling of personal information and includes several key security requirements to protect it. Included in the Act, there are 13 privacy principles known as APPs, but the following 2 are especially relevant to our topic today. So APP 1, the principle requires entities to have a clear and accessible privacy policy that details how to manage personal information, promoting trust and accountability by informing individuals and how the information is handled. And I think nowadays it's really important for all of us that we know how our information is handled. APP 11 mandates that entities take reasonable steps to protect personal information from various threats, such as misuse, interference, unauthorized access, modification, or disclosure. Then there's also the notifiable data breach scheme, and requires entities to notify affected individuals if there was a breach, and also the Office of the Australian Information Commissioner, the OAIC, about a data breach that are likely to result in serious harm. So there, it's important to note that there is a process to follow if you find yourself in a situation involving a data breach. And then the government has also published a long-term cybersecurity strategy plan last year in 2023 to enhance Australia's cybersecurity framework. And this strategy includes various initiatives aimed at improving resilience against cybersecurity threats, and it also aligns with the obligations under the Privacy Act. So there's some context to what is available at the moment and what you should look at. So David, given the context, could you please elaborate on the proposed reforms to the Privacy Act, including some examples?
Sure. So you're going to see a lot of numbers on this slide. Let me try and simplify it for you. So obviously, the Attorney General has gone through and looked at the current Privacy Act, have looked at the recent breaches, other challenges, and they made 116 proposals for reform, right? So those went in last year. And of those, 106 out of the 116 were accepted to some degree. And you'll hear all this language. And in fact, we have in our resources slide a link to this full proposal if someone wants some bedtime reading and has a little insomnia. But 38 of the proposals were fully agreed. That means we know that these are going to turn into law in some form. And then 68 of those were agreed in principle. That means that they will likely turn into law, but there may be some adjustments. It may not follow exactly what the Attorney General has proposed. And so that's quite a lengthy list. Now, when's this going to happen? So the Australian government intends to introduce these to Parliament for legislation in August. So what that means is that that's when the government will start to turn those into law or changes to the law that'll be voted upon. It's unclear right now if they'll go, through all the 106 that, in both categories of agreed and agreed in principle, or perhaps they may start with those that are agreed upon initially, and then move on to the agreed in principle. So what this likely means is that we'll see a draft of some kind in August, and then that will start to go through the legislative process and debate as it turns into law. When will it go into effect? Well, depends on how long the process takes in Parliament, but we know that it'll begin, and we can start watching that process in August. So if we can move on, I can talk a little bit about the high-level summary of changes. And there's a lot more than we see here, but we try to pull out some of the big ones that we'll see. And as we go through this presentation, we'll talk in detail about a few more of these. Or we'll deep dive in some of these areas and talk about what they mean and how organizations should prepare. So obviously AI, generative AI, ChatGPT, you can't turn right or left without seeing something about it right now in the media. It's all over every application you use. And so that has informed one of the leading principles here, pieces they want to address, which is automated decision making. So what is automated decision making? It doesn't necessarily mean AI per se, but AI is largely what has spurred this on. The idea is, are you using technology, AI or more simple algorithms or decision points, to make decisions that can affect people's lives in substantive ways? Renting a home or buying a car, or any of these pieces where you might use AI or other automated means to make this decision that could have a substantial effect on someone's life, and wanting to make sure that that there's some controls around that. And that includes one of the things that's been proposed is the ability to opt out of automated decision making. So you might be able to say, hey, you may include this, but I want to make sure a human being's involved in the process. And so that's one of the elements here, as well as transparency about how these decisions are made. So more about whether this is fully automated, semi-automated, and it's extremely important, to make sure that there isn't bias against certain groups, that things are done fairly, and so on. So this is an important piece. Another is strengthening the notifiable data breaches scheme. So one of the drivers here have been recent data breaches, which Mariaan will talk about shortly. And so one of the things is organizations tend to not want to share information about that, right? So now you can permit information sharing about that. We'll also talk about more specific timeframes from the point at which you may become aware of data breach, and to the point that it needs to be reported, depending on the size and impact and so on, as well as looking at the bad actors. And something we'll talk about a lot today is, what is a bad actor? Most of these laws, most of these are set up really not to find someone who made an innocent mistake along the way, but is trying to, follow the rules and do the right thing. It's the organizations that just look at this and say, yeah, I don't really care. I'm just going to do what I've been doing. And so they want to, relax the threshold for those who are serial repeaters, who keep, violating these rules, and find it easier to just pay a small fine and move on. Well, once you, reach that category, it's much easier to have broader sanctions that are harder to just step away from. Another thing you'll hear a bit about are privacy impact assessments. So privacy impact assessments, or PIAs, are a method by which you can evaluate high-risk data activities. I would say in a lot of organizations, they may be done for any activity that that may deal with personal information. And it's expected that they'll be required at least at a certain threshold level of risk. And so these are typically done at the point that early on in a project, when you're thinking about doing something with personal information, maybe standing up a new marketing system or an HR system, or changing the way that you handle personal information, and assessing what that risk is, bringing that to your legal and business stakeholders, and then having them make a decision. Do we go forward? Do we not? Do we go forward but put in certain controls to minimize the risk? And so this is a process that, if your organizations aren't already doing these are going to become mandatory, at least for certain higher risk. And by higher risk, that usually means using maybe more sensitive types of personal information. This may mean ones that have a bigger impact on people's outcomes, like some of the examples we talked about with housing, or financing loans, things like that. Children. This is a very big topic, I would say, actually globally right now. Most countries are revising their laws around children's privacy. A lot of the laws, I'd say, globally have been a little bit more of a, oh, if we say we don't cater to children, we look the other way. But now Australia is looking at developing children's online privacy code. So if you have an application, a service that is likely to be accessed by children, and Australia's threshold for that is 18 years of age, which is fairly high, then you're expected to follow a certain online privacy code, and that privacy code may include how you get consent from children to use their data, how you present those choices so that they're understandable, and certain limitations in what you can and can't do with minors. Moving along from here, traditionally there's been a small business exemption, and so that's those with less than $3 million. So that's going to be gradually phased away over a few years, and so that the law really does apply more broadly. That the small business exception doesn't mean that your data is just put at higher risk because of the size of the organizations being shared with. Data security and retention. So they oftentimes will talk about how long you need to keep information for tax reasons, for contracts reasons, a number of years. But now Australia is also looking at potential penalties for keeping personal information too long. And I like to say that personal information is kind of like plutonium. It is extremely valuable when it's making energy in a reactor. It's but it's very toxic when it's not producing value. And so there'll be more structure coming from the government around what's expected in how long to keep the information, putting in your privacy notices information so that people who are sharing their information understand what those retention rules are, and then making sure you actually go and delete that information. And then improving information security. So the OAIC will be providing more information around how you secure personal information, you destroy it, you de-identify it. And people often ask, what is de-identification? Or sometimes it'll be called anonymization. And this is ways that you can take personal information but make it, well, no longer personal. You remove enough identifiers that it can no longer be traced to a David Ray or a Mariaan Wagner, but that it becomes information that is potentially may include some personal information elements, but can no longer identify those individuals. And I see we do have a question here, which is what would be considered a high-risk activity? So those activities, and Mariaan, jump in if you have some thoughts here too, but those typically will include things like using sensitive information. Sensitive information could be, religion, race, other things like that. It could be more sensitive identification numbers. It also can be what you're doing with that information. Like I said, if you're making decisions that can affect people's lives, their ability to afford a house or a car, things like that. Any thoughts here, Mariaan?
Totally agree with you, David. It is all in the context what you use the information for that you need to consider whether it could be a high risk for an individual to take care of that.
Yeah, and that's the biggest thing. Context is extremely important. So as we walk through this, we're all familiar with making sure we know where personal information or lives, but this really is context aware. How is it going to be used? That becomes extremely important.
Absolutely. All right. So moving on, Tim. I think we are now at the topic on why is this important for individuals. To David's point earlier, there are 4 sections related to this topic. So if we can move on, I think we know that Australia has faced several significant data breaches in recent years, impacting millions of us as individuals across various industries. Well, fresh off the press, Ticketek experienced a data breach last week, and they are still investigating what was the impact of that. To name a few others, Latitude Financial Services experienced a major data breach in March last year, 2023, exposing the personal information of around 14 million customers. Then we also remember Medibank, a major health insurance provider. They suffered a breach affecting over 9 million current and former customers. And to David's point earlier, how long do you need to retain the data is important, and you need to, in your industry and your type of business, you need to make sure that you know what are those retention policies, especially apologies if you are in the healthcare sector. There are different laws associated to that versus another industry. They are still under investigation by the OAIC for its information handling practices, and they could be subject to a $50 million fine. And on top of this, a separate class action against Medibank is being pursued in the Federal Court of Australia. Definitely not a nice place to be. And then we all remember, I think, telecommunications giant Optus also experienced a major data breach in September 2022. And obviously there are so many others, including Canva, Australian University, etc. But most importantly, these incidents highlight the types of data cyber criminals target. It's personal information, names, passwords, dates of birth, license numbers, tax file numbers, banking account details, etc. That can be exploited for identity theft and other criminal activities such as demanding a ransom. This emphasizes the necessity for businesses to safeguard all personal information. And we will talk about how we can do that, or we can give some advice. But strong data and system access security and your processes, for example, know where your data is, identity management, and also additional protective measures that you can take. So David, could you please provide further details on why it is essential for individuals?
Yeah, and so as I mentioned earlier, let's define what an individual is. And if you're looking at like the GDPR in Europe, they use the term data subject. If you might be looking at some of the US states, they might use the term consumer. There are a number of different words, and where Australia seems to be settling on, although it's not finalized, they tend to, so far the language has been using individual and consumer somewhat interchangeably, but an individual means the person who the personal information describes, that information you're collecting. That typically will include your customers or clients. That can also now include employees. So employee records used to be exempted from the Australian Privacy Act. That exemption is being done away with. And so these are all the people whose data as an organization you may have, their personal information, that you are a trusted custodian of that data and may have responsibilities and heightened responsibilities that the Act speaks to. So these high-profile data breaches that Mariaan just talked about, those have really accelerated the movement forward. So there was always an intent for the Australian government to do these reforms, but these have really put an urgency, which is why it's moving so quickly. And you know the current privacy law is just really not up to date for technology. So as Tim mentioned, Australia was one of the first countries to have a comprehensive privacy law back in '88, but it hasn't been substantially revised since then. And that's before the internet was a thing in most people's homes and in businesses. That is long before AI was something other than you would see in a science fiction film. And so now we're at a point where this law really needs some modernizing, and that's what this is all about. And this also goes in line with the Australian cybersecurity strategy, which is set to run, from 23 to 30. And there are a number of other areas we've talked about as far as minors. This has become, whether it's cyberbullying or it's the exploitation of children's information online, this has become a global concern, and Australia is certainly well aware of this and making sure that's addressed in this legislation. Increased transparency and control. So when we see these breaches or we see data being used in ways that is concerning, one of the standard principles around privacy is, how is my information being used? Being transparent about it, giving individuals control over how their data is used, whether it's used for marketing, whether it's used in automated decision making, how it's actually removed at their request, and really looking at the rest of the world and bringing Australia forward to have greater parity with what the EU has started, but the rest of the world has also been picking up on, anywhere from Brazil to the US and so on. And I do see a question here, and we welcome questions along the way. I think that makes a much more interesting conversation. And so the question is it likely with these changes, Australia will be in a position where we'll need to meet the EU's requirements for third country adequacy? And the answer is, well, yes, with an asterisk. Not the EU's requirements per se, but one of the pieces that is expected to come through is that Australia will be called upon to develop an adequacy regime. Now, whether that's exactly in parity with the EU or somewhat different, that is still remains to be seen. But yes, information that is leaving Australia's borders and going to other countries, Australia is expected to set up an adequacy regime. And for those who don't understand what that means, so let me step back a moment. That means certain countries may be seen as having parity in their privacy laws with Australia, to say yes, these countries are also safe places for me to send personal information because their laws are essentially equivalent and the protections are essentially equivalent. And this is normally done on a country by country basis. So the EU, for example, publishes a list of countries that are adequate. You know, Switzerland's not part of the EU, but they have a strong privacy regime, so they're considered adequate, and so on. Israel is considered adequate because of their strong privacy controls, and so on. And these are revised from time to time as countries have new privacy laws, they change their privacy laws. And so, yes, it may not be exactly the same as EU's, or they may not have to follow what the EU determines to be adequate, but Australia will be having its own regime, and it will probably look to what the EU has done for some guidance. So let's move forward. And so let's dig in a little bit more. So we talked about some of the changes, and I want to talk about the changes in the context of an individual, a person whose information is being stored by an organization. So for most of us sitting here, these are our customers, these are our clients. You know, why is this important to them? So the first thing is individual rights. You know, those familiar with Europe might also hear these as data subject rights. Right now, Australia has some basic ones around the ability to access your personal information that's being held about you in an organization, to correct information that is incorrect. But it's also going to expand to include things like the right to erasure, which means, you know, delete all my personal information. And let me pause there on that point. That doesn't mean that this is an absolute right. So you may have other retention rules, as Marianne suggested. Healthcare may have certain periods of time they need to keep information, or you may need to keep information to manage cybersecurity. You may need to keep information for a variety of other legitimate purposes that could override that right to erasure. So the way this has been deployed in other countries who've adopted this and other regimes is that there are exceptions, but when there are none of those exceptions that apply, then yes, that personal information needs to be deleted and needs to be done within you know, a set period of time, usually around a month. And so this is, I would say, a place a lot of organizations struggle because traditionally systems have been designed not to delete personal information. They've been designed to keep it. And so planning ahead for this one is very important, is how are you going to handle it. And then we'll also talk about it in the context later of not only the, you know, an individual's request, hello, please delete my personal information, but also on a proactive perspective, not keeping it longer than you have to. The other, which is also sometimes called the right to be forgotten, is the right to de-index certain online search results. So this is going to apply more to organizations who provide search technologies, the Googles of the world and so on, but it could also apply in some other context if you have an indexing service where you provide a lot of automated links and so on, where you might be able to say, hey, I don't want to have that information about me still made available. Again, lots of exceptions here. And so those are oftentimes applied very narrowly, and we're waiting to see what the language of that's going to look like. So marketing consent. We talked a bit about transparency and control. So this is another important part where there are already some abilities within the current law to opt out, but it's going to get much more specific. It's going as far as defining what is marketing, what is targeted marketing, and so on. So that you have the ability to opt out of that, the ability to withdraw consent for processing your information in certain ways, targeting individuals with, you know, in certain, you know, with sensitive information. That's where we talked about things like race or gender or other, union membership, any of those types of things. There, again, everything has exceptions. There may be places where there's socially beneficial content, but overall, you need to provide choice and the ability for people to say, hey, you know, please don't use my information for these purposes. And once that's done, that needs to be obeyed. And again, a lot of organizations may not be fully ready for that type of request input and then tracking. AI and transparency. So I think we talked about this pretty well already, but making sure that in your privacy notices, other places that you provide that transparency around AI may have the right to opt out of it in certain cases for automated decision making, and so that's important. We talked about children as well. So with that, why don't we move forward?
Thank you, David. Yeah, we've talked about all the significance of safeguarding personal data for individuals, but perhaps you can elaborate why is it crucial for businesses to prepare for this and how they can achieve it, as it might seem like a daunting task.
It does, and and one thing is, before I get started on the slide, I'd like to ask again, if people have questions, we love Q&A. We'll try to get to them as we go along, and we'll also have a little time at the end for some open Q&A. And so questions that we haven't gotten to, we'll discuss at the end. And so certainly enjoy the interactivity. So most important thing is data trust. And this is a new term that's been around just for a few years now, which is, do I trust this organization with my information? Am I going to, choose with my wallet and choose with my, based on reputation, which company I'm going to use because some have better policies, or I trust the way that they portray themselves as managing my data in ways that I feel more confident with. And so that's an important piece, this concept of data trust, and that is reputational, and that can be a competitive advantage. As Tim mentioned, there are some opportunities here to also move ahead in competitive ways. Fines and enforcement, so they're going up. So the risk of non-compliance, it means that that organizations could end up needing to pay more outward if they are exposed to fines, if they don't do things in the way that that the government expects. Then the other big piece here is the opportunity to get rid of old data. And again, this concept of over retained information has been around forever. But for the longest time, it's been more of a minimum period of time you need to keep things. And there haven't been consequences for keeping things too long, other than storage costs and potential costs in litigation, which really have not been as big a driver as they could be. But now there may be fines and other types of controls coming from the government around keeping information for too long. And so let's talk about the concept of data minimization. And it really means two things. First, don't collect more than you need for the stated purpose. So if you're collecting information to make a transaction online, or to sell an insurance policy and fulfill that, etc., only collect the information that's actually needed for that purpose. Collecting a lot of extra personal information, it leaves information that may be exposed for breach. It has other information that you don't need and could potentially find its way into misuse in your organization. So again, start with the minimum information you need, and then don't keep it longer than you need it, and then make sure you dispose of it when you reach the retention period that you set for that information. And so these are places where you can both reduce your data footprint, which means you reduce the potential data that could be exposed in a breach, and therefore it's better all the way around. And oftentimes organizations, I know, can be resistant to deleting information, and this provides an incentive to do what I think a lot of organizations have wanted to do for a while, which is clean up a bit. And overall, these move Australia more toward a single path for organizations to follow. So Australia, while it has comprehensive privacy law, has a lot of sectoral laws as well that apply specific to different industries, different laws that could pile upon each other for the same issue. And so while this isn't specifically going to replace all those, it's creating a path to create a simpler set of rules to follow, rather than a web of different separate laws around the same information. Let's move forward. So where do you start? So we'll talk first about the program side of things. So, it's providing training, messaging, raising awareness in your organization. And then this really creates a team, right? There's no one person or one department or function in an organization who can do this on their own. It's just not possible. And so the best way is to create a program charter. Identify who are going to be your leads, who's going to run this, who's going to support it, who needs to be notified, and so on, in a cross-functional team. These oftentimes will include people from the business, the places that are going to be most affected, like marketing or HR, data or data governance functions that you may have. Privacy, of course, has a leading seat at the table. Cybersecurity, also extremely important. Technology, who's going to implement this, and how does this affect systems that may have to delete information or may need to have more additional rules on processing personal information. And getting top-down support, ideally from the C-level or the board, is critical because everybody has day jobs. And so it's sometimes difficult to get attention and make this rise to a priority. But when you have that top-down support, it makes this much, much more achievable. And then technology is a huge part of this, as we've been saying all along. It's that turns these things into scale. So start talking with your technology teams. Start looking at the tooling that they may already have, or gaps of tooling where they may want to augment that to help meet these new demands. And then the most important thing I would say here is, the old adage, don't let perfection be the enemy of the good. It's more important to have a plan and get started than to pause and worry and what if and let time pass. And again, something I said earlier that parallels with this is the government's not going to be looking for someone who's trying to do the right thing and may have made a small misstep. They're going to be looking for those that have just not put together a plan. They have no evidence that they're going to get there. They just are not showing a need to comply. And so, again, you want to be one of the good players out there who are trying their best. Marianne?
Thank you, David. Very important information and valid, and it's practical steps to follow. So we've covered and discussed the program areas, which are really important. But more specifically, and with about 15 minutes left, what are the key fundamentals that should be established? If you can perhaps just elaborate a little bit more on those.
Sure. So these are a few key areas that we see in most privacy programs. And the first is data inventory, knowing where your data is, because at the end of the day, everything else sits on top of this, right? If you don't understand where personal information is and the context, how it's being used, then everything beyond this really is not very meaningful. And so this is the most critical piece. How do you go about this? There are a number of different ways. There are what we'll call top-down activities, where you can go and interview the various parts of your organization, maybe use surveys and other tools to collect information from individuals. And then there are what we'll call bottom-up activities, scanning data and actually looking for personal information, because people's memories and their are oftentimes fallible. And so, really recommend bringing both of those activities together. So you can look at the broader organization and understand where to start, places that you may want to start to look and how information is being used. But then, as I like to say, trust but verify. But also use scanning technologies to identify things that don't turn up in those conversations, or that may find information that people just not realize they had. So that's step one. Step two is individual rights. So by individual rights, these are access reports. Show me the information you have about me, or correct my information, or erase my information. And so we expect, as we've seen in other parts of the world, that that when these new rights come in, or even though they've existed before, say in Europe, they existed before the GDPR, but they were much more specific afterward and expanded, much like what Australia is looking at. The volume goes up. It's in the news. People are paying attention. They're going to want to go and see, oh, what information do these people have about me? And so we recommend having a process in place to intake these requests and be able to fulfill them relatively quickly. We don't have specifics yet, but in most regimes, it's typically 30 to 45 days from the point at which a valid request comes in to the point that the request needs to be fulfilled. And there are technologies that can help with this to help with the intake of those requests and to also help automate the fulfillment based on data that's been scanned and so on to really make this easier to turn around in a short period of time, and two, more accurate, include information that individual manual processes may not find. Then the next is consent and marketing. We talked a fair bit about this already, but choice, whether it's opt out of direct marketing or opting out of automated decision making or other types of choices that are being presented. That's very important that you have an easy way that individuals can make those choices, review those choices, change them when they want to change them, withdraw consent. And so again, much like individual rights above, it's not only you need systems that track this, but think about what the user experience is, because this is what goes back to data trust. How do I exercise those choices? How do I know what choices I made? Incident response. So we've talked a fair bit about breach, whether it's heightened fines, shorter times to notify, and so on. So you'll want to have tools and processes in place to identify when there's an incident, evaluate whether it rises to the level of a breach that may be notifiable, and figure out how to respond both from a cyber perspective, cutting it off and getting to the analysis, but also, when do you have to notify individuals, and how are you going to do that? Privacy impact assessments, we talked about these a bit already. They're already required in the public sector and for Australian government, but the expectation is that they will now be required again for private businesses as well, at least in areas where we talked a little bit about higher risk decision making, though I would say that it's becoming more and more standard to have some level of impact assessment whenever there's a new system or process that's going to use personal information. But again, they may be mandatory at certain thresholds. Policies and transparency. So there are going to be new requirements as to what should be in a privacy policy. What's the notice that's on your website that talks about how you collect information and what you share. And there may also be some new requirements around the point when you collect personal information that you have to share more about what you're going to do with it and how you're going to manage it. And then we've talked a fair bit as well around data minimization and retention. So collect less, dispose of it when you no longer need it, and have a clear plan that you're going to be expected to state how long you keep personal information in your privacy policies, and then once you state them, there's going to be an expectation you follow through. And I do see a quick question here before we move on, which is, are there any organizations locally or globally that are managing their data well? So this is a tough one because you don't like to call anyone out either positively or negatively. I could point to an example that's just top of my mind here in the US, which is Sephora, which got in trouble with the state of California, which has a comprehensive privacy law around this. This was around consent and tracking for marketing purposes, and they claimed they didn't do it. And it was very clear from the regulators using some scanning tools that they were in fact using cookies and other tracking technologies. And so they continually tried to make the argument that they didn't need to comply with the law, that they weren't doing these activities when it was apparent that they were, And so they were one of the first fines with this new California law. So that's an example of what not to do. As far as who's doing it well, what I would say, I wouldn't say necessarily who's doing it well per se, but some of the user experiences that I would say to look to and are things like Google, and they have a page where you can manage your personal information. And so, that type of experience where you have a lot of control is sometimes set as a high standard. Now, that's not to comment, positively or negatively on how Google handles personal information, but just that particular experience is helpful. So if we want to move on to resources, and Tim, why don't we just jump right to the resources slide? And so we are going to share this presentation. We're going to make it available for attendees. And so don't worry about having to write all this down quickly. But we've shared some of the resources we used in pulling together this deck, including the Australian government's response to the Privacy Act, which lists out all of the agreed in principle and fully agreed elements. If you really want to get into the details, that's available online. There have been a number of law firms in Australia who have done some really great summaries. We referred to some of those, and so on. So again, we'll make this deck available, including these references to you. Let's move forward. So, do we have any Q&A? I know we've had a few great ones along the way. We do have about 8 minutes left, so want to open this to the audience. If there are any other questions on what you've seen, we'll do our best to try and answer them.
Thank you, David. I think while we're waiting for some questions to be raised in the Q&A section, interesting topic also about the cross-border data that we companies need to be aware of. And sometimes you think, I'm an Australian company, I only have to abide by the Australian laws. And but if you perhaps have a call center in another country, so that is additional laws and regulations that you need to be aware of. Any comments on that, David? Any more information on that?
Yeah, so we're going to expect the Australian government to set up, like I said, an adequacy scheme. So they'll look at some countries and say, these countries you can send Australian personal information to, and they're considered to be safe and adequate. Others that may not have the same adequacy, doesn't mean you can't necessarily send data there, but you're probably going to be looking at certain contractual terms that you have to have in place that specify that the organization you're sending it to is going to protect that information in ways that an Australian citizen or resident would expect. And so again, we're waiting to see those come forward. But the important piece is that Australia, like a lot of other nations and regions, is going to be looking at controlling this exfiltration, because that's oftentimes a place where if it goes to a nation or an area that has less control over personal information, weaker laws, that can put that information to a greater risk of exposure.
Thank you, David. Very helpful information. We do have another question here. Can we recommend a list of suggested tools to help in privacy assessment and monitoring from both an SAP and an enterprise perspective? Good question.
Sure. So privacy assessments, there are a number of vendors. I'll be selfish in saying BigID is one of them, but there's also OneTrust, Security.ai, and a number of others. I recommend looking at Forrester's recent wave of privacy vendors, and a number of them all offer the ability to send out these assessments and share those. When it comes to SAP, I will be a little self-serving because I know that BigID is one of the vendors that can scan SAP and look for personal information. And we are actually available, purchased even through SAP. I'm sure there are others. I'm not sure off the top of my head. Let's see another question here. The exact timing of privacy reforms, other than knowing that it's going to be introduced to Parliament in August, we don't know a lot more. Given the urgency, particularly from the data breaches and the one you just mentioned, Mariaan, each time one of these happen, it seems to move the government a little faster.
Yes.
If I had to guess, perhaps next year, but we don't know yet.
That's very true. Then there's one more question. Do you have any comments on the Australian government's cybersecurity strategy? Well, it's a long-term strategy. If I can make a comment on that, it was introduced last year, and it's a long-term strategy until 2030. So I think the government is acknowledging that there's a lot of things to look at and to put in place. So I think just walk with that journey. Make sure that you are, constantly monitoring that strategy. Be aware of any changes to that strategy as well, because I think they will also strengthen it as we go along. Because I think we all, including the government, learn as we go. Tomorrow there might be something new, and they will have to adopt the policy or the strategy at least to stay ahead. David, any comments on that?
No, I think you've covered it well. It goes in parallel, as I like to say. Privacy and security are two sides of the same coin. You can't have one without the other. So another good question here, and I think this is a great question because it shows where it's the indexing can be a bit unclear in the way it's stated. So the question here is, we currently use BigID in our company, and we use it to automate our individual rights processes, and that they index on email. Well, the new Australian proposals on indexing affect this aspect of scanning. The answer is no, I don't believe so. And the reason is that when we talk about the right to remove your information from indexes, my apologies, it tends to be looking more at publicly facing search engines or other places where your information might be used inappropriately. So I'll give you an example from Europe. There was a businessman who had some legal troubles at one point, and then everything was overturned. It was found that that there were no issues, that he was expunged, legal record expunged, but historical articles saying that he had done certain things were still showing up in Google and other search engines, and so it made it hard for him to do business. And that was one of the early cases in Europe to say, okay, yeah, there is a right to say, hey, Google, where possible, can you remove the links to these old articles because someone's being disadvantaged in a negative way? This is always a very controversial feature or rights, and it's got a lot of limitations. And sorry, my little Google device heard Google, so there we go. Let's unplug that. And so no, in this purpose or use, BigID is being used to comply with these laws, and to do these rights. It's going to be no right to remove it from your index as long as you have a legitimate use to have that information, and the purpose you're doing is actually to protect someone's privacy. It's really going to apply more to search engines and so on.
Thank you, David. I think we've got 1 minute left. Tim, I'm going to hand over to you. If you can perhaps do the closing for us, please.
Yeah, thank you very much, Mariaan. Thank you very much, David. I think it was very informative. I know obviously it's a lot to cover in such a short period of time, and thank you very much to the audience for all the questions. Well, naturally, there's a bit to kind of consider here, and I think if I took one thing away, the time to act is now. And I think David, you put it best when you said, "Don't let perfection get in the way of good." And so with that in mind, for any of those on the call who would like to kind of consider what does good look like for your organization, we're happy and pleased to offer on the behalf of Turnkey, a quick 30 minute workshop with the team to kind of just get a baseline of where you are at and some of the things to consider. For those that aren't quite ready to consider that just yet, please stay tuned as we'll be running a series of follow-up sessions and initiatives and activities on the back of this. But for now, we'll obviously, as we've said, share the slide deck with all who attended today. Thank you again for your time. Thank you again, David and Mariaan, for your wisdom and effort to pull this together. And looking forward to speaking to you all again soon.